All rise, please. Court's back in session.
Thank you.
Where is she?
All right, we'll do that. Yeah, go ahead.
I need to meet with her. I'm not agreeing. No.
Judge, I've got one I can call up real quick. Mr. Koontz, we passed for this afternoon.
Okay.
I have spoken with Mr. Koontz. I spoke with Ms. Barrickman. They have made an offer today, but it's not something that I can advise him to take today. I need to look into it some more. We've made a counteroffer. I don't know if the state's going to, long and the short of it is, we need to pass him for February 26th.
All right. Okay, February 26th. Thank you.
Thank you, sir.
There you go.
Your Honor, there's also an out of custody that does not have an attorney, Devin Little, if we may call his case, he's set for arraignment today. And that case number is 23 CF 2418.
Okay.
And I did have an offer for Mr. Little, but he informed me that just recently there's a new arrest. So I informed him we can arraign him today, and then
All right.
it's probably going to be an offer that he wants to accept depending on the new case. But we can just arraign him today and I guess come back on his arraignment date for the new case, and I'll have a global offer.
All right, you're Devin Little.
Yes, sir.
All right, this is 23 CF 2418. You're here on arraignment. You're charged with possession of a controlled substance without prescription, third-degree felony, possession of not more than 20 grams of marijuana, first-degree misdemeanor, possession of narcotics equipment, first-degree misdemeanor. Would you like me to appoint an attorney to represent you?
That would be very thankful.
Okay, I'll appoint the public defender. Mr. Gibbs.
He said he has a new case. Has he been, is arraignment pending on that?
No, I'm out on both of them,
Is that for 1228? Can we just track both cases together?
basically.
Yeah. We will.
Or do we want to leave it on?
Separate.
Well, we'll bring him back on, was it 12, the next one? 1227, and she said they may be able to work it out.
Say 9
Yeah,
a.m.?
I think Ms. Glisten said she's going to try to get us an offer.
Yeah,
So
I'll have a global.
you're pleading him not guilty.
We'll plead him not guilty on everything now, put it on 1227.
1227, okay, thank you.
And, yeah, we'll go that way. So that's our
Should be at 9.
Yes, sir. Yeah. Give us a call to talk with your attorney.
All right.
We are, I have some out of custody.
All right.
Your Honor, the first one is Douglas Centerfit, number 20, 23 CF 2440, charged with burglary of an unoccupied conveyance. Will tender not guilty plea at this time. Request trial by jury.
All right, how about February 26th?
Please call the office.
You get it resolved, you can move it up.
Thank you, Your Honor. The next person that I have that's out of custody is number 24, Lauren Valmajoa. Your Honor, we're going to enter a not guilty plea to the charges if they're there. We have charges?
She's charged with, in 23 CF 2424, carrying concealed firearm, possession of alcohol under 21, DUI with injury and/or property damage, marijuana possession not more than 20 grams, 4 counts of possession of narcotics equipment. Plead not guilty?
Yes, Your Honor. Request to the 2/26 court date.
All right, February 26th, thank you.
Your Honor, another one that I have on the docket is number 19, Susan Porter. We did a waiver of appearance for her. And I'm going to enter a not guilty plea and request trial by jury. Would ask for the 2/26 date.
All right, February 26th.
Your Honor, I have a few out of custody as well. Judge, the first person I'd like to call is James Bass. Your Honor, Mr. Bass is present and approaching. Judge, this is 23 CF 2416. Judge, this is a battery case. I believe that the alleged victim, Ms. Frymark, is present. I was hoping to do an oral motion to modify contact in his case. I believe Ms. Frymark does want to at least have contact with Mr. Bass, so I would move to modify the mode contact to no violent contact. I'm happy to inquire of Ms. Bass, or Ms. Frymark if the court
Your
requires.
Honor, I'm objecting because there is no motion that I was able to review. I haven't had the possibility to thoroughly speak with the victim. So I'd object to that. If defense agrees to move it to a later date, I'll be fine to argue it, but not at this time.
All right, well, she needs a chance to talk with their victim, so.
Otherwise, Judge, we'd enter a not guilty plea and leave this set for pretrial.
All right. You want December 27th?
We can do 2/26, Judge.
All right, February 26th.
Thank you.
We have an order to vote this along, Mr. Bass.
Lovely.
Yeah.
Apparently, they have an order to take you back into jail.
Okay, I mean, it was supposed to be good.
I don't know. We'll look at it and we'll see what we can do, okay?
Yes, sir.
Yeah, that's okay.
Yeah, keep it.
Your Honor, next I have Mr. Emil Batson. Your Honor, Mr. Batson is present and approaching. This is 23 CF 2350. Your Honor, we'd enter a not guilty plea, request 15 days for any pre-arraignment motions, and demand trial by jury. Leave this set for pretrial, Judge.
All right, you're charged, Mr. Batson, in 23 CF 2350 with possession of controlled substance without prescription, third-degree felony, driving license suspended, habitual second or subsequent offense. Is that a misdemeanor? First-degree misdemeanor?
For a third-degree felony.
Third-degree
Judge,
felony.
Level 1.
So your attorney's pledging not guilty will set you for, what, 1227? Okay, thank you, sir.
Mr. Batson also has a warrant you're going to have to serve.
Lovely.
1227.
It is a FTA for a misdemeanor. I know you came with,
Mr. Hall is my attorney, which is in their office.
It's not my case, so I don't know anything
well, it's
about
for a
it.
misdemeanor case.
Is there a no bond on it?
No, it's $6,000 cash and pro.
Okay.
You say that one's for
226, please, for Mr. Matt Batson as well.
All right, 226.
That's the last warrant that I have on the docket. Everybody else, you can relax.
Anyway. Everybody can breathe. Judge, the next person that I have that's out of custody this morning, or this afternoon, is Isaiah Durham. Your Honor, Mr. Durham is present. He is approaching the well at this time. This is 23 CF 2433, Judge. We'd tender a plea of not guilty, request 15 days for any pre-arraignment motions, and demand trial by jury.
All right, 226, Mr. Durham.
Thank you,
Okay,
Judge.
thank you.
So those are just your official charges. Call my office to make an appointment. I believe the only other out of custody that I have on this afternoon's docket, Judge, is Lester Brown. Your Honor, Mr. Brown is present and approaching. Judge, this is 23 CF 2354.
All right,
Afternoon.
hello?
Judge, will tender a plea of not guilty, request 15 days for any pre-arraignment motions, and demand trial by jury. Leave this set for pretrial.
February 26th. I'll get these cases resolved, move them up.
Judge, I've got one more out of
Just give me a
custody.
call. We can probably do a phone appointment. Here, this is yours. And then,
Oh, I'm sorry. I thought you
sorry,
were
the
done.
only other case, Judge, for the 2 o'clock docket, I have Michael Bullaboy set on the 2 o'clock docket. He's an inmate. We're going to go ahead and request to continue him. We're working on getting GPS records from probation at this time that we want to present at his evidentiary hearing. So I'm requesting to continue to, I think the beginning of January should be plenty of time.
January 4th.
January 4th? January 4th, Judge.
Okay.
Thank you, Judge.
Judge, I've got Caitlin Holler. Ms. Holler's in the courtroom. Ms. Holler, if you'll approach. I filed a motion to withdraw on her. I just approved it in stack, so it would have been electronically filed over the lunch break. We represent the alleged co-defendant, Mr. Centerfit, and that's the basis for the conflict. I don't know if the court wants to go ahead and arraign her, or if the court wants to bring her back with RCC present. I think the court can go ahead and arraign her.
What we'll do is, this is 23 CF 2438. Ms. Holler, you're charged with burglary of an unoccupied conveyance, a third-degree felony. Possession of controlled substance without a prescription, first-degree misdemeanor. The court's going to plead you not guilty. Appoint regional conflict counsel and bring you back on February 26th. Okay? How about getting me an order on that, please?
I will, Judge.
Okay, thank you.
Your Honor, there is one that's set for the 2 o'clock docket that's out of custody that's here.
Okay.
You want to go ahead and handle him? His name is David John Parker. He's here for violation of probation, 18 CF 1223. It's my understanding that the offer was to revoke and terminate, and $100 cost of prosecution, $150 PD fee. Any outstanding restitution can be paid through the clerk or sent to collections.
What's his name?
John
He's
David
on the
Parker.
2 o'clock. You want
He's on the 2 o'clock. Terminate. Okay. Okay.
So you want to admit,
Actually, you want to just dismiss it because we're running out of time?
Yeah, Judge, state would recommend the court to dismiss the violation and revoke and terminate per the probation's record.
all right, I'll revoke and terminate
And
probation.
just send the money to collections, or 90 days to pay, and then send it.
90 days to pay your fees, or it goes to collections.
All right, thank you.
Okay.
Thanks for pulling inmates. First be Bray, Kevin Bray. Bray. Please, Judge.
Your Honor, Tim Gibbs on behalf of Kevin Gray. This is 23 CF 2408 and 23 CF 2409. Judge Weed enter a plea of not guilty on these charges. Request 15 days for any pre-arraignment motions and demand trial by jury. We can leave this set for pretrial 226.
February 26th, thank you, sir.
Thank you, Judge. Come see me as soon as I got more information. Okay.
Mr. Demmons, stand out here next to you, please, Judge.
Your Honor, Tim Gibbs on behalf of Marcus Dimmons. This is 23 CF 2352. Judge, we're here for arraignment as well as a motion to reduce modifier set bond. I'd like to proceed with the bond motion first, if that's fine with the court.
I'm sorry, Mr. Gibbs, I'm not aware of the motion.
It was filed on November 21st.
All right, this is 23 CF 2352, Marcus Demons, charged with trafficking in synthetic cannabinoids, 280 grams or more. What is that, a second-degree felony?
It's a first-degree felony, Judge.
First-degree felony? All
As
right,
charged, I believe he actually has a 3-year min-man based on the statutes, based on the amount that was
3-year minimum
alleged.
mandatory. Is plead not guilty,
Judge, we'll tender a not guilty plea for today, but we do have a bond
February 26th.
for that.
All right, what's
A motion
what's
to reduce
current-
modifier set bond. Apparently that was added to the clerk's website to benchmark Tuesday, but I thought I had filed it 21st.
what's
No,
his
it's the
current-
28th. I'm fine, though.
Okay.
I waived my objection about the not filing, it's okay. I had actually seen it. You were requesting a $40,000. I'll be agreeable to $50,000.
You think you can make $5,000? Judge, I believe he would be able to make, if it was $50,000 cash professional, he'd be able to come up with that amount, or an amount for a bondsman. So we'd be okay with the court reducing it to that amount, maintaining his, any pretrial supervision that may already be in place. Currently, he's got a $75,000 bond that's just out of his reach. He's not able
Is
to
he
furnish that.
local? I mean, is he got?
Yes, Judge, he would be living here in Crestview.
All right, provide $50,000 cash professional pretrial services supervision.
Thank you, Judge.
Thank you.
And then we'll leave him set for
February
2/26.
26th.
Thank you, Judge.
Is this Stewart? Okay, we're gonna switch to do Stewart real quick, and then we'll bring Dobbs out. I believe it's your last one.
Oh, I withdrew from Dobbs, but okay.
Oh, okay, well then.
We'll bring her out.
This is Elena Stewart.
Your Honor, this is Alana Stewart, 23 CF 2430. She's charged with trafficking in methamphetamine, 14 or more but less than 28, trafficking in fentanyl, and introduction of contraband, possession of drug paraphernalia. We're going to enter a not guilty plea, request trial by jury, request the 2/26 date.
All right, February 26th.
So we don't even need it at all. Well.
Or we could bring this Dobbs out.
She has, you just hired Mike Flowers. So he- Jennifer Flowers, okay, so.
We can still
bring her in now.
We'll bring her out. That's fine.
Bridget Dobbs. And the clerk tells me.
Your Honor, I represented Ms. Dobbs. We had found a conflict, so we moved to withdraw and appoint RCC. I believe Your Honor did sign that order appointing Ms. Flowers from RCC to represent Ms. Dobbs. I think Ms. Flowers already filed a written plea of not guilty, noted waiver of arraignment. Ms. Flowers is right there. Yes, this is Ms. Dobbs.
We'll set her for February 26th. Bridget Dobbs, 23 CF 2369. And I'll appoint Regional Conflict Counsel.
Thank you, Judge.
Then Lawson?
Who? It's mine, Lawson.
Amanda Lawson.
Judge, this is Amanda Lawson.
Okay.
If the court will give me just a minute. Judge, we may be able to resolve this one. Let me write one up for her.
Okay.
And if we can bring her back out a little bit later. We'll try to get that done for you today.
Madden, come on. Mr. Mattingly.
Judge, this is James Mattingly. Okay. Judge, I'm going to enter a plea of not guilty on the case, request 15 days for any pre-arraignment motions, and demand trial by jury. It's possession of a firearm, ammunition, or electric weapon by a convicted felon.
All right, February 26th.
Thank you, Judge.
Knopfsinger?
Yes, sir.
Nelson?
Nofsinger, Nofsinger. Come on out, Mr. Nofsinger. Judge likewise entered a plea of not guilty on Mr. Nofsinger's behalf, waive reading of any information, and request 15 days for pre-arraignment motions and demand trial by jury.
February 26th.
Thank you, Judge. Now, I had an Amanda Mattingly on the docket.
She's not in custody, or at least not in the county jail.
All right, I had her as being in the county jail. Is there an Amanda Mattingly in the courtroom? Judge, actually, I've got she may be in drug court. I've got an email on the front of the file from Ms. Henderson about her going into drug court. If the court could pass it, and we can try to check into that. Okay. And other than that, Judge, I don't have anyone else. I'll start working on the plea agreement.
Tyshawn Morris.
We handled him this morning.
We did, Judge, along with Mr. Hart.
Chamberlain.
That one would not be mine, so I would not know.
Darian Chamberlain.
I don't believe he has an attorney, right?
Do we know anything about, was he served?
Good.
We have Darian Chamberlain here. No
Your Honor,
bond
he should
keep.
be in federal custody. He's not here.
Federal custody.
Yes, Judge.
No bond habeas pending first appearance.
Yes. Upon the federal government issuing an indictment against him, we may dismiss the case here, so.
Yes, we took care of Willie Dern. He was out of custody.
And Shamar Anderson?
We took care of him this morning.
What about Ronald Way?
I think Ms. Rivers addressed him this morning. Is that
That's on for the 7th.
Pardon?
It's on for the 7th.
Oh,
That puts us on a 2 o'clock docket.
is that it? Then, right now, we have Kevin Johnson with Ms. Dudley.
Yes, sir.
My 2 o'clock docket, Judge, is Stephen Creech. It's a sentencing hearing following his jury trial from September. I don't anticipate it taking more than half an hour.
What about Ms. Dudley's case?
Yeah, because you didn't bring the.
What you got, Ms. Dudley?
Motion to suppress, Your Honor.
Pardon?
Motion to suppress.
Oh. And we got another one with Hartzog, motion to suppress, I believe, right?
No, we got the 3850.
And the 3850?
Yes, sir.
Pardon?
Yes, sir, then the 3850 is set for 2 o'clock as well.
Let's do Creech's sentencing.
Let's go ahead and bring him out. Your Honor, Tim Gibbs on behalf of Stephen Creech. This is 21 CF 2680. Judge, we're here for sentencing. We received a mitigation evaluation from Dr. McDonald for Mr. Creech, where she does recommend that he meets one of the particular statutory criteria. I'd like to admit her report. She is not here. I did not subpoena her to be here. We received this evaluation, I believe, Tuesday, and we filed it with the court the same day. I don't know if Your Honor's had a chance to review it. I don't know if the court needs Dr. McDonald here so that she can authenticate and admit the report. If that's the case, we would request to continue so that I can get Dr. McDonald here to testify at least to the authenticity of the report.
I'll be objecting, Your Honor, to both the continuance and to the report of Dr. McDonald.
Well, if If it was just sent Tuesday, is that right?
I filed it with the court Tuesday, that's when I
I haven't
received
seen it yet. So I want to look at it before I
We,
send it.
and I believe, I do have a copy of the PSI as well. I want to also make sure Your Honor's seen that.
Because I haven't got it yet. I mean, we're just, with all this internet problems and everything,
Right.
I hadn't seen it. You want to make sure I see it, get it to me in paper. So we'll continue his sentencing to,
I guess January 4th would be the next available date, really, realistically.
January 4th.
And from there as well, Judge, I'll confirm that Dr. McDonald's confirm her availability and file any appropriate motions if necessary.
That's fine.
He's in jail. January 4th.
All right, thank you, Judge.
Thank you.
What's the next shortest?
What do we have with Antonio McLaughlin?
It's Miss Glisson, is the 3850.
Oh. Michael Bullaburo?
That one, what is it?
He'd already.
Bullable. It was continued, Judge, to, what did he say, January?
I see Mr. Hardy, he was on the 9 o'clock.
Yeah, where's Mr. Hardy? Come on up. What you got?
The first case I have is Timothy Holt.
Who is it?
Timothy Holt.
Judge asked about Bullet Boy.
Oh, I'm sorry, Judge. Earlier I continued Mr. Bullaboy's cases to January 4th as well.
All right. And then you are here for Timothy Holt?
Yes, Your Honor.
Okay. Where is he? Right.
Your Honor, we just want to get Mr. Holt back on the trial docket. The December 27th, we left it on today. About a motion to dismiss, we're still working on that. We had some new information come to light, so I just want to get him back on the trial docket.
You want to go with pretrial December 27th or
Yes, Your Honor.
February 26th?
December 27th.
That's fine, Judge.
Okay. Thank you.
Yes. Your Honor, Mr. Pursley had gotten a new plea offer at the last court date. We're still talking about it. I want to put him back on that December 27th trial docket as well.
What about December 7th?
That'd be actually better.
December 7th.
Yes, thank you, Your Honor.
Okay.
That's all I have.
Your Honor, that concludes all of my business, if I may be excused.
All right, thank you.
Thank you, Judge.
All right,
Judge, we can recall Ms. Lawson.
okay.
Ms. Lawson, recall her. She announced that she wanted to accept the state's probation offer.
Any idea what we're doing after Lawson?
Oh, I don't have anything myself after Lawson. Did you still have a hearing of some sort? Okay, I think you'll just be doing with Ms. Dudley's case and perhaps RCC's.
Did we recall Amanda Mattingly already, or confirm the drug court?
No, we have not recalled her, but we don't have any information that she's in drug court.
Your Honor, I tracked with drug court, and we don't have anything in reference to her pleading into drug court at this time.
And she's out on 2 cases.
Continue to December 7th.
All right, Judge, we'll try to get her in.
All right.
All right, Ms. Lawson, I've done up the written plea agreement for you, okay? You have all the rights that are associated with the trial, since we're not having a trial. Unless you've got something else holding you in, though, this will get you out today. If this is what you want to do, I need your signature here. You may have had some monitor or something like that. Okay. I'll mention something about it. I'll mention something to the clerk on the record. This is also fairly early in the day, so you should have the same. There you go. Score sheet. Yeah. Now, if you live like in the south, back meet with them briefly today here in court, and then you're going to come back and they're going to instruct you further. Okay. Judge, we have a negotiated plea agreement as well as.
Amanda Lawson, would you please raise your right hand and be sworn? You swear the testimony you give before this court is the truth, so help you God.
Yes.
And this is 23 CF 2449, State of Florida versus Amanda Lawson. You want to enter a no contest plea, the charge of possession of a controlled substance, a third-degree felony, and possession of paraphernalia, a first-degree misdemeanor, correct? Did you read and sign this plea and sentencing agreement form?
Yes, sir.
You understand the rights you're waiving by entering this plea?
Yes, sir.
Has anyone forced you or threatened you to enter this plea? Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today? Are you happy with the work Mr. Williams has done for you on your case?
Yes, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it. Judge you guilty, sentenced you 1 year probation. Drug evaluation and treatment. Random UAs. Stay away from scene of arrest. Standard court costs, cost of prosecution, and PD fee. And adjudicated guilty on both counts. Anything further?
Nothing further, Your Honor. Okay, you should be. Oh,
Okay.
one thing, apparently, in a previous case, there was an issue getting the paperwork over to the jail. Madam Clerk, if you please make sure that the judgment sentence gets over to or the clerk notes, whatever it is you normally send, gets over to the jail so that she can be released. That's for both cases. I just have the one file in
Your
front
Honor,
of me.
can I
That's
double
both
check that I
counts.
gave you the global score sheet as opposed to just one case?
It's just a one case.
Excuse me just a second. What other case are you talking about? I only have the one case on also.
Oh, listen, I'm sorry.
You're thinking of Maddie?
Yeah, I'm sorry. I can't say that.
I was about to say, I thought I just did Lawson. Okay.
No problem.
And Your Honor, supervision, please wait.
Yes.
Thank you.
Okay, thank you.
Thank you, Judge. Yeah, you'll need to speak with them.
All right, so, who else do we have? Is Flowers, what did you have with McLaughlin?
Yes, we have 3850. It's
Oh, yeah.
probably
Okay.
needs to
Let's see.
Ms. Dudley had one, she appears to have stepped out. And then we have Mr. Shaw.
Judge, I can poke my head out real quick, see if I can get Ms. Dudley in for you.
No, she just goes to the restroom.
Well, we might as well just start with Hartzog.
Here, I'll put my finger for you.
All right, this is 2020 CF 2976. Jesse Alexander Hartzog. I believe this is a motion to suppress, correct?
That's correct, Judge.
All right. State ready?
State's ready, Your
All
Honor.
right, go ahead.
Your Honor, I believe we go forward on the four corners of the warrant, so we are ready to proceed with argument.
Okay. No witnesses?
No, Your Honor?
All right, go ahead. I guess the defense. It says defense's motion.
It is, Your Honor.
Go ahead.
I assume we gotta put the warrant in evidence, so. You want me to just announce the stipulate to the attachments? It's
Yeah,
attached to our
it's
motion.
attached to yours, yeah.
What'd you say, what was attached?
The warrant itself, not the other attachment.
She's got it, she got it. Judge, Tim Shaw and Jay Patel for Jesse Hartzog, case number 20 CF 2976A. At this time, and pursuant to agreement with the... Do you have, we're going to put in the warrant itself, Judge, and the affidavit in support, I assume, is attached to it?
That's what's attached to yours.
Okay.
It was Exhibit A. Your attachment was Exhibit A.
Right, with the affidavit in support.
Correct.
Right.
Exhibit A, though. Not B.
Judge, we would move in, the court, I'm sure, has a copy of the motion suppressed that we had filed in this matter, which has attached thereto Exhibit A, which is the search warrant itself, and the attachment to the search warrant was the affidavit in support of the search warrant. So I believe without objection, we're moving that into evidence.
Your Honor, that is without objection. It was Exhibit A, I believe, to the defense's motion to suppress. We have no objection to the court considering that as evidence in support
You
of
got a
these
paper
arguments.
for me to look at?
May I approach?
Okay. Right.
Judge, Mr. Hartzog was charged with an amended information which was filed on or about August 6th of 21. In that particular amended information, there are 24 counts. They all begin as a result of counts 1 through 5, which were alleged photographs, videos obtained as a result of the search warrant, which we're here on today. That search warrant was issued on or about February 19th of 2020, and it requested, or which authorized the search of all digital evidence associated with Snapchat username White Choco Boy. That's a copy of Exhibit A that we just talked about. The affidavit in support, paragraph 2 under factual support on page 1 of the motion, indicates that all of these, this information which led to the search warrant began by a case, we call it Yanni Giannis. During the state's case against Mr. Giannis, the state, excuse me, law enforcement indicated at paragraph 2F on page 2 of the motion reads, furthermore, while the search warrant affidavit indicates that Giannis' account sent images of child pornography to the White Choco Boy account, there is no information regarding whether these images were A, viewed, B, reviewed, or responded to, or otherwise knowingly observed by Mr. Hartzog. Because the images were sent by the Giannis account to the Hartzog account, the affidavit then indicates that law enforcement, quote, has reason to believe that there is the possibility of additional evidence in violation of Florida State Statute 827 in the Snapchat account, Hartzog account, which is a Snapchat account to be searched. That search warrant was issued by Judge Mason. And I think it's important under Memorandum of Law, beginning on page 3, for the court to get a background on what the law is with regard to this. And what the law is, it says, importantly, courts have consistently held that a magistrate's responsibility is to perform his neutral and detached function and to not serve merely as a rubber stamp for the police. And it says C, in interest of MS 455, Southern 2nd 557, which is a Florida 4th DCA 1984 case. In that regard, the United States Supreme Court has held that courts must insist that the magistrate purport to perform his neutral and detached function and not serve merely as a rubber stamp for the police. A magistrate failing to manifest that neutrality and detachment demanded of a judicial officer when presented with a warrant application and who acts instead as an adjunct law enforcement officer cannot provide valid authorization for an otherwise unconstitutional search. Reviewing courts will not defer to a warrant based on an affidavit that does not provide the magistrate with a substantial basis for determining the existence of probable cause. Sufficient information must be presented to the magistrate to allow that official to determine probable cause. His action cannot be a mere ratification of the bare conclusions of others. Even if the warrant application was supported by more than a bare bones affidavit, a reviewing court may properly conclude that notwithstanding the deference the magistrate deserved, the warrant was invalid because the magistrate's probable cause determination reflected an improper analysis of the totality of the circumstances. There's a United States versus Leon case, 468 U.S. 897 at 897, 1984. It says, along the same vein, in evaluating a search warrant affidavit, a magistrate cannot accept purely conclusory statements. I'm going to dispense with the next few citations. An affidavit must provide the magistrate with a substantial basis for determining the existence of probable cause. A search warrant cannot rest on mere affirmance of suspicion or belief, and conclusory statements fail to meet the probable cause requirement. Instead, the trial court should determine whether substantial evidence supported the magistrate's finding that based on the totality of the circumstances, probable cause existed to issue the warrant. Probable cause to arrest exists when the totality of the facts and circumstances within an officer's knowledge sufficiently warrant a reasonable person to believe that, more likely than not, a crime has been committed. Harder versus Edwards, 174 Southern 3rd, 524 at 534. That's a 4th DCA 2015 case. While probable cause is an admittedly low standard, it cannot be based on pure speculation. Probable cause cannot be based on mere suspicion, but must be based on facts known to exist. Furthermore, probable cause has been deemed a practical common sense question which involves factual and practical considerations of everyday life on which prudent men and women act. And there's a cite to Mesa versus State, 77 Southern 3rd, 218 at 223, Florida 4th DCA 2011. Ultimately, if the affidavit in support of a search warrant does not establish probable cause, the evidence obtained as a result of the search must be suppressed. I'm going to skip down to the bottom of page 5 here, Judge. As applied here, the search warrant affidavit was completely insufficient to establish probable cause. In that regard, the affidavit only indicates that the Giannis account sent images of child pornography to the Hartzog account. There's nothing else in the warrant which would indicate that Mr. Hartzog received or obtained those images. Furthermore, in reviewing the images that were purportedly sent to the Hartzog account from the Giannis account, it appears that Mr. Hartzog did not review or knowingly possess them. In that respect, there are numerous images sent and no response is made by Mr. Hartzog to acknowledge receipt or review of the images. Under Florida law, to establish possession of child pornography in violation of section 827.071 Florida statutes, the state is required to prove knowing possession of the images. In fact, Elias versus State, in Elias versus State, the 5th District Court of Appeal recognized this fact in overturning the conviction of a man charged with the same offense. That's 308 Southern 3rd, 1127, and 2020 5th DCA case. In Elias, there were 7 images which were located on a CD but not found on any of the electronic devices in the defendant's possession. With respect to these counts, the court found that the state failed to establish a, quote, knowing possession of the lack of evidence of the defendant had ever viewed the images and accordingly knew they contained child pornography. The state failed to present any evidence proving the defendant ever viewed those specific images or otherwise knew those 7 images were sexual conduct by children. There's a Strauss case, Judge, that relied on a federal decision, United States versus Tucker. And Tucker is highly instructive here on the analysis of knowledge, where computer files are involuntarily sent to a party who is then charged with their possession. In Tucker, the court considered a scenario where the defendant voluntarily visited web pages containing child pornography, but his web browser involuntarily cached the images onto his computer. The court found that because the defendant had voluntarily searched for and viewed the images, he could be charged with their known possession. However, and importantly here, the court noted that had the images been involuntarily received or viewed, the court's finding with respect to knowledge would be different. See also United States versus Love, 696 Fed Appendix 297, 11th Circuit, 2017, reiterating that knowing possession requires proof that physical possession was not mistaken or inadvertent. These decisional authorities make clear that merely being sent images of child pornography by a third party, by an electronic medium, without any indication that such was viewed or saved is insufficient to establish possession of child pornography in violation of Chapter 827 Florida statutes. Without some factual assertions to support a conclusion that these images were acknowledged or reviewed, the warrant simply does not set forth adequate facts and circumstances to establish a violation of Section 827.071 Florida statutes. With respect to any potential good faith argument, Mr. Hartzog notes that even the warrant affidavit itself contains a self-professed doubt with respect to probable cause. More specifically, the affiant indicates only a belief that there might, and quote, it's in the affidavit in support, possibly be some child pornography in the rest of the Hartzog account, communications, or correspondence. Any magistrate, law enforcement officer, or third party would recognize on the face of the search warrant that a mere possibility that evidence of a crime will be found falls far short of probable cause. Adderholt v. State, 592 Southern 2nd, 1081, holding that probable cause means a fair probability that contraband or evidence of a crime will be found, not a mere possibility. And then NH v. State, 358 Southern 3rd, 477, Florida 5th DCA, 2023, noting that while probable cause is not a high bar, it requires a probability or substantial chance of criminal activity. Considering A, the elements of possession of child pornography under Section 827-071 Florida statutes, and B, the express requirement that such possession be knowingly, the sole fact that the Hartzog account had been sent images of child pornography from the Giannis account without any factual support whatsoever that those images were viewed or received, and D, the contrary proof established that Mr. Hartzog's essential ignoring of the images, and E, the search warrant's affidavit's own admission that the belief of a criminal act was a mere possibility, the court must find that the affidavit was unsupported by probable cause. Furthermore, the affidavit is so devoid and self-professedly inadequate that no officer could have reasonably relied upon it in executing the search at issue. For this reason, any evidence which was obtained as a result of the issuance of the warrant is subject to suppression. Judge, I would like to point out, and I have pulled up.
Hartzog's account was the white Choco boy.
I'm sorry?
Hartzog's account was the white Choco boy.
That's correct. The Giannis account is the account that allegedly sent images of purported child pornography to that account. The important thing, and I think the court, if I can, under the jury instructions, Judge, 16.11, possession, control, or intentional viewing of child pornography reads, to prove the crime of either possession, control, intentional viewing of child pornography, the state must prove the following three elements beyond a reasonable doubt. This affidavit in support of the search warrant misses clearly on two of them. The first element is that the defendant, Mr. Hartzog, either knowingly possessed, knowingly controlled, intentionally viewed a photograph, motion picture, exhibition, show, representation, image, data, or computer depiction or presentation. Doesn't say anything about whether it's pornography or not. They have to show that he viewed an image, whether it's child porn or not. They don't even have evidence of that. Element two, the photograph, motion picture, exhibition, show, representation, image, data, or computer depiction or presentation included in whole or in part child pornography. And then element three, which they can't meet, is that the defendant knew that the photograph, motion picture, exhibition, show, representation, image, data, computer depiction, or presentation included child pornography. And it also is important for the court to be aware that in order to have for a finding of probable cause that a particular person committed a crime, there's probable cause to believe a particular person committed a crime. At the time the warrant was issued, they didn't even know who White Choco Boy was. So they don't get to any, there's three elements. Two of them are completely devoid based on this affidavit in support of the search warrant. And there's absolutely, based on the four corners, there's absolutely nothing on which the court can base, or the magistrate could have based probable cause in order to grant that, or to issue that search warrant in this particular case. And everything that flowed from that, everything prior to that was Gianni, the Gianni account, the search warrants that were made on Gianni's account. There's nothing at all in this affidavit in support of the search warrant that indicates, that would even remotely suggest there's probable cause to believe that Jesse Hartzog had intentionally or knowingly possessed or viewed any child pornography. There's no evidence of that at all. They don't have a response from him, oh, thanks for sending this to me. They didn't go in his computer at the time of this video, the search warrant, and show that he had accessed any of the videos or photos or anything of that nature. And they had that ability to do it, they just didn't do it, and they don't have evidence of it. It's purely a fishing expedition on the part of law enforcement and this affidavit in support of the search warrant. I mean, 1 second, Judge. I don't have any further argument at this time, Judge.
All right, Ms. Boston.
Your Honor, the defense is using interchangeably probable cause to obtain a search warrant and probable cause for an arrest warrant. As the court is very well aware, there are different standards. In order to get an arrest warrant, we do have to prove for probable cause each and every element of the crime, as Mr. Shaw suggested, if we were to arrest the defendant for possession of child pornography. However, Your Honor, we are here on a search warrant that was for an account. It's analogous to, for instance, a search warrant that would be going into a residence. In order to obtain a search warrant, officer must come to the court and establish that there is probable cause to believe that evidence of the crime will be found at the location to be searched. The court certainly has reviewed many search warrants and knows that that is the standard. It is not the same standard as if we were coming to you with an arrest warrant. I would basically analogize it, Your Honor, as if this were a drug case, for instance. If a law enforcement officer came to the court and said, Your Honor, I know as law enforcement officer that a package containing fentanyl, for instance, was delivered to this residence. I know the contents are contraband. I know it was delivered to that residence. I have no reason to believe it went anywhere else. Your Honor, we can now establish that we believe there is evidence of a crime, the possession of fentanyl, to be located within that residence. The court would be then within its rights to grant that search warrant. That would be within the parameters that are established by case law. There is no need at that time to establish that the owner of that residence knew the contents of that package. We're only seeking evidence of the crime stated with particularity within the location to be searched, and that is what was required. To take that into the digital world, Your Honor, the law enforcement has often come to the courts, and again, this court has reviewed these warrants on many occasions, as had Judge Mason, who did review this warrant. If law enforcement comes to the court and states that we believe that a device has been sending or receiving child pornography, images of contraband, and that device is located within a home at the given address, then we would have established for the court that there is evidence of a crime, or we believe there's evidence of a crime, the images that are being shared and received by a device within that home, and that would then be sufficient to enter that home. We would not have to show at that time that the owner of that home knew that a device contained child pornography therein. That's why the search warrant allows us to go in, seize the devices, then examine them, and at that point, then law enforcement must establish, prior to getting an arrest warrant, of course, that the owner of that device knew the content thereof. This is no different, Your Honor. In this case, law enforcement had information that the Yanni account contained within itself child pornography, and the officer had viewed those images and knew they were child pornography. So that is established. The officer was able to articulate in the affidavit that she knew the images she viewed were child pornography, which are illegal. She was also able to articulate that that Yanni account sent those images known to be child pornography to the White Choco Boy account, thereby establishing exactly what was required. That contraband, the evidence of child pornography, those images known to be child pornography, much like the fentanyl I talked about earlier, were sent to an account. So now it's probable cause to believe that those images are within that account, same as the fentanyl was within the home. This is no different, but that is the standard that is required, and we do believe that that standard was met. There is no requirement for a search warrant to establish that the owner of the house knew the contents of that package. There's no requirement that the owner of the White Choco Boy account knew the contents thereof. The search warrant authorizes officers to go in and seek evidence of a crime which was stated with particularity, child pornography, images of child pornography that were sent there. The place is stated with particularity. It's the account to be searched, White Choco Boy. And we believe that is directly within the requirements of what law enforcement must present within its affidavit within the four corners in order to obtain a valid search warrant. And we believe that is exactly what was presented to Judge Mason in this case. It's what the court has before it right now, and we believe it is a valid search warrant. And we ask the court to uphold the findings of Judge Mason that it was a valid search warrant and allow us to proceed with this case.
Sean?
Thank you, Judge. And of course, we will disagree with Ms. Basso on what this court has to find, and we certainly implore this court not to confuse this with a drug case. This is not a drug case. There's a brand new case, Judge. It's State of Florida versus Thomas Peltier, Peltier, which is, I've got the Florida Law Weekly site, D2057B. And the discussion in that case begins, the United States Constitution demands that, quote, no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. And this is cited United States Constitution, Article 1, Section 12. The Florida Constitution provides virtually identical protections. And it goes on, this case goes on to read, to establish probable cause. This is a search warrant case. This isn't an arrest case. This is a search warrant case. To establish probable cause, a supporting affidavit for issuance of a search warrant, quote, must satisfy two elements. First, that a particular person has committed a crime. This is a search warrant, unlike what Ms. Basso is trying to tell the court. First, that a particular person has committed a crime. They don't even know who White Choco Boy is. And that's the commission element. And second, that evidence relevant to the probable criminality is located at the place to be searched. That's the nexus element. Evidence relevant to the probable criminality. That's why I went into the elements of the crime. Without elements of the crime being proved, you don't have criminality. You have no criminality at all. So they don't have a particular person, and they don't have the elements of a crime. They have a fishing expedition, Judge. And if the court were to give any credence to Ms. Basso's idea that this is somehow analogous with a drug case, I would point out that the affidavit itself indicates that the warrant was issued on February 19th of 2020. The alleged photographs, which were never acknowledged, no proof that Mr. Hartzog had ever seen them, didn't even know whose account it was. That alleged CP was sent, allegedly, on July 15 of 2019. So that's 7-8 months earlier. So, Judge, we would implore the court to find that there was a lack of probable cause for the issuance of the search warrant. This is a search warrant case. This requirement to establish probable cause supporting an affidavit for issuance of a search warrant, what I just read to the court, this is a search warrant case, and it requires a particular person and probable criminality, and without the elements being met of a crime, there's no criminality. So we're asking the court to grant the motion. Thank you.
Well, let me see that case. Is that a first DCA case?
It's a second DCA, Judge, and it's October 25th, 2023. Madam Clerk.
Well, I read this case, it says the trial court erred in granting the motion to suppress.
Judge, that's on a different basis. If you want to look at the factual issues in that particular case, that case stands for the proposition as set out in the highlighted portion which I read to the court. It was reversed on, my recollection is it reversed on the basis that the trial, they didn't attach the actual child pornography to the affidavit. So the argument, part of that argument then was, well, how do you know it was actual child pornography that was sent? And the District Court of Appeals, Second District Court of Appeals said, well, even without that, the law enforcement officer himself had sufficiently described the child pornography within the affidavit in support of the search warrant. But we still can't get around that it has to be a particular person and it has to be the elements of a crime, the criminality has to be met. And they have neither on this case.
Well, have you seen this case, Ms. Basso?
I have not, Your Honor.
Well, y'all send me proposed orders. I want to study this case.
Thank you, Judge.
I mean, this case just came out a couple of weeks ago.
Your Honor, does the court have the site for that? I can get it from Mr. Shaw.
It's 48 Florida Law Weekly, D 2057, I believe. Send me a proposed order and attach additional argument with case law not to exceed 3 pages. Additional argument.
Time frame, Judge.
I'll give you 2 weeks.
Thank you,
Is
Judge.
that good enough? 15 days? So three pages of additional argument, because I haven't, this case just came out. And attach any case law that you want me to review that's not already cited or provided.
Thank you, Judge. And in keeping with the procedure of the motion hearing as we were having it today, we would have an opportunity to respond to any argument that Ms. Basso makes as a rebuttal, as we did today.
Well, y'all exchange each other's memorandum and submit a rebuttal 5 days after that. How about that?
Sounds good, Judge.
Here's your case back.
Thank you.
Attach that to your proposed order.
We will.
So y'all understand my order?
Yes, sir.
Prepare me an order, which I just announced orally.
Thank you, Judge. I don't think we have anything further on this matter.
All right, thank you.
Thank you, Judge.
Here's your, let me give you, here's his paperwork back.
Given, I think that we have the next pretrial, do you want to keep it on or just go ahead and continue it?
Retrial is when?
I think it's in like 2 weeks.
We'll continue the pretrial then to, is the pretrial December 27th?
I think it's the 27th, Judge.
27, 26.
It's between Christmas and New Year's. So.
We'll try,
No, the 27th, yeah, sorry.
we'll change it to pretrial February 26th.
That's what I was thinking, February
He's out of custody, so,
26th.
Thank you.
Yeah.
okay. Ms. Dudley?
Mr. Harvey.
Is this Mr. Johnson?
Yes, sir.
Okay.
Let's see if I can find the case.
Your Honor, we have a motion to suppress in 23 CF 210, State versus Kevin Johnson. Motion to suppress the search warrant issued in this case. In the affidavit in this case, law enforcement states they were doing surveillance on a different residence, which is not the residence that was searched. They had information that narcotics were being sold at that residence. They alleged during that surveillance, they saw the defendant at that residence most of the day, and they observed what they said were hand-to-hand transactions. They had a witness who lives at the residence, Mr. Kevin Russell, tell them that the defendant sells narcotics from the porch of that residence, according to the search warrant. Because they believe he sold narcotics from his vehicle. At that point, they said they saw several hand-to-hand transactions, and then they saw the defendant at an empty lot next to that residence. And that residence on Wilson Street, and they saw at an empty lot, they saw, they believe, a hand-to-hand transaction. They followed Mr. Johnson, they say, from Wilson Street to McClellan Street, which is where he lives. They observed no traffic. They didn't do any surveillance on that residence, according to the search warrant. They did a trash pull, and they got residue out of the trash pull that tested positive for narcotics. On the second trash pull, they said it was inconclusive, so they didn't get any evidence of narcotics out of that trash pull. Nowhere in the search warrant do they allege any activity was occurring in that home. No surveillance on that home. What they have is the defendant went from one address they believe he was selling narcotics at to his home. They conducted no controlled buys. They did no traffic stops. They didn't stop anybody who said, hey, I got drugs from the defendant. Even if they did, there's no evidence that there was drugs inside the home. The one trash pull where they did get residue that tested positive, they said it was one tied up grocery bag they found some plastic bags in. They stated that they didn't state that there was any mail related to that residence found in the trash can. There was nothing in the trash can that indicated that those items came out of that home. The officer said, based on their training and experience, people who deal in narcotics keep drugs at their home. And they did a criminal history search of the defendant and found that the defendant had prior convictions for narcotics. Based on that, they got a search warrant for the defendant's home at 988 McClellan Street. The law in this case states that no warrant shall be issued for a search of any private dwelling under any conditions except on sworn proof or affidavit of some credible witness that he or she believes the said conditions exist inside the home. So what we're dealing with is what evidence did they have to say there were narcotics inside the home? And Howard v. State, the first DCA states that you have to strictly construe 933.18 that as a present known violation of narcotics in law must exist in the home to be searched prior to the issuance of a search warrant in order for a search warrant to be valid. In this case, they had nothing. At best, they had was one trash pull that resulted in residue from the trash can outside with no mail, nothing tied into the home, and no other indication of anything occurring at the home. Because everything they did, all the surveillance, everything they did was at a different location, not on the McClellan Street home. The law also states in Dias v. State, Coronado v. State, this first DCA case and the second DCA case, that mere speculation that some evidence of criminal activity might be found if a broad enough search is permitted is insufficient to support the issuance of a warrant. The warrant must establish a specific nexus between the place to be searched and the evidence for probable criminality. In Dias v. State, law enforcement watched the defendant do a controlled buy and then return to his home. They were able to get a search warrant in that case. That search warrant was suppressed. Just because something occurs outside the home does not mean there's evidence that something is inside the home. That the court ruled that was just speculation. So even if you can get an inference that the defendant's residence, generally they keep drugs at their residence, that's still speculation. And speculation is not enough to get a search warrant. In Thompson v. State, first DCA case, 1989, and the Howard v. State, which is also a first DCA case. In that case, the defendants were growing marijuana directly next to the residence. Even with marijuana being grown next to the residence, that was insufficient to justify a search of the home, because it has to be occurring inside the home. In Giselle v. State, which is a 4th DCA case, 1999, law enforcement did one trash pull. They found a Ziploc bag, had 0.1 grams of marijuana. They also had an anonymous tip that there was drug trafficking occurring inside the home, and there was short-term traffic. The court ruled that doing one trash pull from the garbage outside the home was not sufficient, either by itself or in conjunction with an anonymous tip that residents at the address were dealing in narcotics, to indicate a fair probability that cannabis would be found inside the home. The officers did not conduct any surveillance or independent follow-up to corroborate the tip, any additional trash pulls, or develop any other pattern of drug activity at that home to establish the probability that cannabis would be found inside the residence. It said the contents of the trash was not enough to support a conclusion that there will be drugs found into the home. In Rawlinson v. State, the 4th DCA 1998 case, said although the affidavit contained relevant information that the substance found in one trash pool tested positive for cannabis, the affidavit lacked sufficient material to indicate a fair probability that cannabis will be found inside the residence. While the state argued in there, I think the response that there were 2 trash pools, one trash pool is the only thing that tested positive. And it was in a bag without any mail, anything indicating that trash came from that home. There was no surveillance on the home at all. All they had is their belief that the defendant was conducting drug sales somewhere else. They did no control by, they stopped no one. They had no one say, yes, I got these drugs from the defendant. They never got any drugs that came from the defendant. So we believe that that's probable cause. The law states when a search warrant is so lacking in probable cause that good faith deception does not apply. And I believe that applies in this case. I believe the state states in their response that with the officers, based on his training and experience, the law also states the training and experience of the officer does not get him around probable cause. Simply because the officer says, based on my training and experience, I believe a crime is occurring inside is a conclusory statement and must be rejected when determining probable cause. And that is in Burnett v. State, 848 Southern 2nd, 1170, 2nd DCA case, and it was citing the U.S. Supreme Court case, Nathan v. United States, 290 U.S. 41. In multiple cases where there's no probable cause, the court has said good faith deception doesn't apply. It's an objective standard, and it states no objective officer, when probable cause does not exist, will reasonably rely or believe that a search warrant will be valid. In Coronado v. State, Getchell v. State, which is 2nd DCA cases, both of those cases state where there is no facts that support the conclusion of any evidence of a violation of Chapter 893, which is what they were going for in this case, will be located inside the residence. The warrant is invalid. Florida courts have consistently refused to apply good faith deception in cases where supporting affidavit clearly fails to establish probable cause to justify search. And that is in multiple cases. First DCA cases are Thompson v. State, Dixon v. State, Howard v. State. 2nd DCA cases, Garcia v. State, where it showed that the good faith deception shouldn't apply. And Getchell v. State, it outlines what Bonilla v. State, sorry, Your Honor. It outlines the ruling in U.S. v. Leon where the good faith deception comes from. But it also outlines instances where suppression is still appropriate and where the good faith exception does not apply. And one of those 4 bases is where the warrant is based on an affidavit so I can get additional probable cause as to render official belief in its existence entirely unreasonable. And that's the situation in this case. There was no probable cause to believe there was items in the home. All we have is law enforcement saying in their affidavit they were doing surveillance on other residents, they saw the defendant there, they saw what they believe was hand-to-hand transactions. They have a guy saying that the defendant sells from the porch of the home, but they never got any drugs from the defendant, from anybody who got drugs from the defendant. And because the defendant lived at this residence, and they did one trash pull that gave them residue of narcotics that they believe drugs were in the home. There is no evidence in this case that drugs are in the home, and the law is very clear when there's no probable cause that the good faith exception doesn't apply.
Okay. Ms. Leon.
Yes, Your Honor. First of all, the facts as they were characterized by the defense, they're accurate to some extent. So there was the search warrant was approved after an extensive investigation. I want to point out the court's attention to one issue. The house of the defendant was under surveillance. Defense stated there was never. And it's on page 6 of the search warrant. The premises to be searched, CPD officers checked the premises to be searched before 9 a.m. and after 7 p.m. for approximately 4 months. They observed the defendant's vehicle parked at the premises to be searched, at the residence of the defendant, and they haven't seen any other person entering their residence. So that's one thing. They established that that was the defendant's residence, also because he was on probation at the time for drug charges, and that was the address the probation office had. The probable cause of this search warrant was based on several factors. One, it was established that the defendant was dealing drugs because it was observed by Crestview Police Department, who then alerted Okaloosa Sheriff's Department to conduct the investigation. There was a short-term traffic on South Wilson Street, which is not the residence of the defendant, but is where the location where the defendant was selling drugs. Not only was observed by individuals, it was observed by not an anonymous person, a person named, a witness named Kevin Russell, who was a resident of South Wilson Street, and he saw the defendant selling drugs to the public. Not only this, the defendant was observed, there was surveillance at that location where law enforcement officers saw hand-to-hand transactions and short-term traffic. Not only this, they also noticed that he would also, the defendant, sell drugs out of this lot that is known. That's a fact that was missing from the defense's argument. That lot is known for a place where people go buy drugs, drug dealing place. The defendant was seen by law enforcement being at the lot, engaging in a short-term transaction hand-to-hand, and then going back to his house. He was followed there. Go to his house, and then leave his house. Minutes later, go back to the activity. In the opinion and experience and training of the investigators, the defendants going to the house and back to the lot meant that he goes to refurnish himself of the products that he wants to sell, and then he goes back to the lot to sell it. Then subsequently, they did 2 trash pulls. First trash pull revealed paraphernalia with cocaine residue. It was presumptively tested, and multiple, I don't have a count of this, multiple baggies with the corner torn off. That's indicative, per the training and experience of the law enforcement, of people packaging drugs. Because what they do, they either use jeweler's bag, the little baggies, to put the drugs in, then they resell them, or they use those bigger plastic bags they stuck the drug in the corner of the bag, they twist it, rip it, and then they sell it. So there was evidence of multiple of these bags with the corner ripped off in the trash can belonging to the defendant. The second trash pool didn't reveal any, it was inconsistent, not inconsistent, inconclusive, I'm sorry. The results of the baggies that were found was inconclusive, but the number of the bags without the corner torn off was 70. That, for law enforcement, was indicative of packaging of drugs. Not only this, another factor that normally is considered by law enforcement when applying for a search warrant is the criminal history record of the defendant. Now, in this particular case, the defendant had, as the court would put it, a very extensive resume of sale of narcotics, starting back, and it's listed in the search warrant also. 1995, delivery of a controlled substance. 1999, possession of synthetic cannabinoid. 2001, cocaine possession with intent to distribute. 2006, sell, manufacture, deliver cocaine. 2009, cocaine, sell, manufacture, deliver, and marijuana production. 2020, sale of synthetic cannabinoids. And at the time he was of the search warrant, he was on probation on another case for a drug-related case. Florida law provides a presumption of validity of search warrants, and the defendant has to prove that the search was invalid. The magistrate's initial determination that probable cause to issue a search warrant exists is entitled to great deference and must be upheld unless there was no substantial basis to conclude that probable cause did exist. And this is found in Dice v. State, a case that the defense brought up. Section 933.18 of the Florida statute provides that a search warrant shall not be issued unless the law relating to narcotics or drug abuse is being violated therein, and obviously here it is. For a warrant to be valid, it must contain an allegation that a present or known violation is occurring in the home to be searched. Now, what's important is that the law requires a court in deciding whether there was probable cause or not for a search warrant to consider the totality of the circumstances. Granted that, were we to analyze each single step that this investigation took, each single step by itself would not provide probable cause. But when seen in the totality of the circumstances, it's obvious that there's more than a fair probability that contraband would be found in the premise to be searched. And that is the standard, Your Honor. Fair probability that the illegal contraband would be found in the premises. We're talking about probable cause and not beyond a reasonable doubt. And as a matter of fact, in Illinois v. Gates, which is one of the most important cases when it comes to search warrant, it says, in determining whether probable cause exists, the trial court must make a judgment based on the totality of the circumstances as to whether the information given indicates a fair probability that contraband will be found in a particular place and time. Determination of whether probable cause is found, and that's repeated in case law, about the totality of the circumstances and the fair probability. There are two factors that have to be met. The defendant committed the crime or is identified, and that the evidence will be likely located inside the place that they want to search. The magistrate's duty is to examine the affidavit in support of a warrant for search of a private dwelling for facts and fact-based conclusions. In this case, there were fact-based conclusions, and they were not mere speculation what the investigators found. The cases that the defense has brought up where the search warrant was ultimately the motion to suppress the search warrant was granted present totally different facts, and not even 20% of the facts of our case. For example, Dias v. State, cited by the defendant. The facts supporting the probable cause were, one, controlled by, which took place in a public area, not at the house of the defendant, and they observed the defendant engaged in short-time interaction with other individuals, and then the defendant was found in possession of 20 grams of marijuana. So it's obvious, the state would agree that probably in this case, there was no probable cause to go search the defendant's house because there's nothing in the facts that link defendant's activity to the house. Our case is different several ways because there was several observations of end-to-end transactions at the lot, the driving back home, going back to get more contraband. The two trash pulls, they revealed those items of paraphernalia consistent with the distribution of narcotics, not simple personal use. Again, 70 bags. In Howard v. State, again, case brought by the defendant. They approved a search warrant based only on the observation of law enforcement. They noticed that within the curtilage of the home of this defendant, they were growing marijuana. That's all they had. So they sought a search warrant, and that search warrant was ultimately, the evidence was suppressed. But again, it was only the observation of that marijuana growing. We have several facts. Not only this, Your Honor, there is no bright line rule establishing the type of steps or how many steps an investigator has to complete before applying for a search warrant because each case is different. And it doesn't say that there has to be more than one trash pull, 2 or 3. It doesn't say that. It keeps talking, the case law keeps talking about the totality of the circumstances. Gesso v. State, again, is different from our case. In that case brought by the defense, the officer did not conduct any surveillance or independent follow-up investigation to corroborate an anonymous tip. We don't have any anonymous tip. We have an actual person, Kevin Russell, who communicated to law enforcement. He was interviewed, and he said that at his house, in the driveway, defendant was conducting those transactions. U.S. v. Anderson, instead, it's a 11th Circuit from 2005. In that case, there was one trash pull, and they found paraphernalia in that one trash pull. There were a residue of heroin. And then the law enforcement observed the defendant in open air drug market. They didn't even observe him dealing drugs, but they observed him close to known drug dealers. We don't have just the defendant being close to known drug dealers. He was dealing drugs. We know that he was observed by law enforcement doing that. Now the same court, U.S. v. Anderson and then United States v. Arguel, both cases established that the criminal history is very important consideration when seeking an arrest warrant to determine the probability that the contraband would be found and that this particular defendant committed the crime, the possession. Not only, additionally, there is this other case, Anton, U.S. v. Anton, 11th Circuit, where it talks about the fact that law enforcement knows that, and it's an opinion, that drug dealers don't keep all the contraband on their person when they go sell it. They take some and they leave the rest or the majority in a place that is not going to be affected by, I don't know, thief or a drug dealer. So So the residence is one of those places where no drug dealers will keep their contraband. And that's what is contained also in our search warrant. The statement that drug dealers, what the drug dealers do, and now investigators, due to their training and experience, are able to verify. Now, obviously, for a search warrant to be approved, it has to go through several steps. First comes to the state's attorney's office. They have to review it, and obviously, if it's they approve it, then it goes to the judge. In this case, Judge Catchell made the determination that there was probable cause. Even if I would argue also that the good faith exception argument would apply in this case, because it's not true that there was no probable cause whatsoever based on the facts that I just stated, and they are actually stated in the search warrant. Basically, the good faith exception provides that if an officer relies on the warrant signed by a magistrate and they perform the search, so in that case, the search would be considered valid. I don't see, I believe, the state believes that there is probable cause in this case to search the defendant's home based on all the facts as stated, and the good faith exception would apply as well. So the state requests that defendant's motion be denied.
The first thing I will address is the state's argument that because a judge signed a search warrant and the officers relied on it, then the good faith exception applies. That's not the law. The law actually says if the signature of a judge established good faith on the part of the police officer, then evidence obtained pursuant to a search warrant in violation of the Fourth Amendment would never be subjected to exclusionary rule. You can't just say, the law is not that because somebody signed a search warrant, that means the officer gets good faith exception. It doesn't say that. The state argued that Dias v. State and Howard v. State is not similar to this case. I would argue that they had more evidence in those cases. In Dias v. State, they did a controlled buy on the defendant. They did a controlled buy. They got drugs from the defendant, and he went back to his home. They had other information on short-term traffic at his home. And they still stated, first DCA stated, that was insufficient to get a search warrant for the home because the controlled buy did not occur at the home. Simply because an incident occurs somewhere else does not mean that because the defendant lives somewhere, you get a search warrant for their home. And Howard v. State is the same thing. The drugs are outside the door of the defendant's home. Outside the door. And that's not enough to get a search warrant for inside the home because there's no evidence that drugs are inside the home. To say that those cases clearly had no probable cause, they have more evidence on the premises than it has in this case. In the search warrant in this case, the entire surveillance of saying he did hand-to-hand transactions, saying that he was selling narcotics, was not at his residence. We're not disputing that McClellan Street is his residence. But all the information they had was that all the narcotics were being sold on Wilson Street, not at his residence. To say that they had a crime being committed, okay, but you have to have a crime being committed at that residence. There's evidence of a crime at that residence. The entire search warrant deals with their surveillance of Wilson Street, the house on Wilson Street. The entire search warrant talks about they believe he did hand-to-hand transactions on Wilson Street, not at McClellan Street where he lived. So they said they went there before 9 o'clock and before 7 p.m. to do surveillance. They did nothing to try to establish that narcotics was going there. They had no tips that narcotics was going there. Everything they had said drugs were being sold on Wilson Street. So they may have information drugs were being sold on Wilson Street, but not that drugs were being sold out of the address on McClellan Street, which is what they listed as their basis. Their basis, the crime they said they were going in for was possession with intent to distribute. They had no evidence of that crime occurring inside their home to get a search warrant. They said they had 2 trash pools. The second trash pool was not paraphernalia. Nothing tested positive for narcotics. The state said they found paraphernalia twice. They did not. The second trash pool had no positive tests for any narcotics. The first trash pool, they said it was 1 bag in the trash can. They pulled it out. Inside the bag, they found some paraphernalia, and it tested positive, I think a piece of foil. Tested positive for cocaine. That's it. They have alleged no short-term traffic, nothing that connects any narcotics to the inside of that residence, and that's what a search warrant's for. In Dias v. State, Howard v. State, Thompson v. State, these are all first DCA cases where they state that is not enough to get inside the home and that the good faith exception does not apply because there's no probable cause. And Leon, US v. Leon, states that that is one of the bases where the exclusionary rule applies, that there is no exception when there is no probable cause. And in this case, there was no probable cause to say that the defendant had any drugs that he possessed with the intent to distribute inside the home, which is what they were saying they were going in for. To say criminal history, okay, but criminal history doesn't say that he had drugs inside the home. It just says that he has convictions for narcotics. We believe that there is no probable cause in the search warrant, and that the good faith exception does not apply based on the case law that's provided. The one case, I think one of the cases the state mentioned was U.S. v. Anderson, which is based off of California law. It's based off of California law, but not based off of Florida law. First DCA is very clear. U.S. v. Leon is very clear. There is no probable cause when you can't establish a crime occurring inside the home. That's the nexus. Just because they believed hand-to-hand transactions occurring on Wilson Street, they did nothing to even corroborate that. But that doesn't mean that there were crimes occurring inside the defendant's residence based on them getting a tin foil out of a bag with residue, and that's the only paraphernalia they received. They had nothing else tying any criminality to the home, and even with that, they got no mail, nothing saying that that bag came out of the home. Based on that, we ask the court to grant the motion to suppress.
Well, I'm gonna let y'all have 15 days to submit me proposed orders with additional argument up to 3 pages. I want to take another look at those cases.
Yes, sir.
Okay.
Your Honor, I did file my response. Would that be enough for the court?
If you feel like it is. I'm not mandating that you give me anything, but give me a proposed order.
Yes, sir. I think we're set for February, I believe. Is that correct? Madam Clerk?
Okay, we have, okay.
We're set for February, yeah. We're good.
All right, now we got McLaughlin, so we'll take about a 20-minute break before we start on the next one. Okay?
All rise, please.